I can stick around if you like, or whatever we need to do.
Yeah, that would be great, just for a few minutes.
Okay.
Just waiting till 6 o'clock. I'd like to call to order the North Topsail Beach Zoning Board of Adjustment special meeting, Thursday, February 29th, 2024, at almost 6 p.m. Can I have the adoption of the agenda, please?
I move to adopt the agenda as received.
I second it.
All in favor?
Aye.
Thank you.
Madam Chair, I hate to interject so early, but if Ms. Hill intends to do some additional training regarding the email she sent me, we probably need to add that to the agenda.
It's on the agenda. Item 4, I'm sorry, 5.
Okay.
Is that sufficient?
That will work.
Okay. Approval of the minutes from January 24th, 2024, special meeting. Can I have somebody?
Again, I make a motion to approve the minutes from the January 24th, 2024 special meeting.
I'll second.
All in favor?
Aye.
Aye.
So approved. New business. Case V-24-02, variance request, Jeff Lucas.
Okay. Ooh, we'll swear in all the witnesses. Or, did you want to, I'm sorry, did you want to go through the sheet or,
Yeah.
oh, sorry.
Yeah.
I'm jumping the gun, sorry.
That's okay. The next item is case, as I said, V-2402. The hearing on this matter is quasi-judicial in nature and will be conducted in accordance with the special due process safeguards. All persons who wish to testify in this case should have signed up on a special sheet for the hearing. If you have not signed in and wish to speak, please sign in now. All those wishing to speak, please proceed to the podium to be sworn in.
You guys want to stand over there? Raise your right hand, place your left hand. Do you swear or affirm that the evidence you shall give to the board in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Attorney Edens?
Thank you, Madam Chair. This is a variance request, and as I understand it, the applicants are Mr. Jeffrey Lucas and Ms. Judy Brown, and they've also authorized NDS Inc. to speak on their behalf. They are requesting, and I'll let the applicant explain it more and staff explain it more, essentially a variance from the town's UDO table 5.5-1 dimensional requirements to elevate an existing 23-foot by 40-foot double-wide mobile home at 2399 Island Drive. As you've already indicated, this is a quasi-judicial hearing that will be conducted in a manner to ensure both procedural and substantive due process. Essentially what that means is we'll treat this somewhat like a court hearing, but not as strictly as we would in court. We'll follow the North Carolina rules of evidence. All witnesses, as you've already done, Madam Chair, must be sworn in. They will be subject to cross-examination as well as to questions from the board. The applicant is entitled to a fair and impartial decision-making body. So I need to ask the board as a whole a few questions along those lines. And Madam Clerk, if you'll just, a lot of times when I ask these questions, people will just shake their head no or something like that. But if you'll just note, there's no positive response if that's the case. So the first question I have is, does anyone on the board have a financial interest in the subject matter of this variance application?
No.
No.
Okay. Does anyone have a business relationship or familiar or family relationship with the applicant?
No.
No.
I realize you may already be aware of where this property is located, but for purposes of this hearing, my question is as follows. Has anyone made a trip or a site visit to this property at 2399 Island Drive for the purpose of assessing this variance application?
No.
No.
Okay. Has anyone had any conversations with staff outside of the context of this hearing regarding the substance of this application?
No.
Has anyone had any conversations with the applicant or anyone acting on behalf of the applicant regarding the substance of this application?
No.
Can any of you think of any reason that would prevent you from being fair and impartial and basing your vote tonight solely on the competent material and substantial evidence produced during this hearing?
No.
No.
Okay. To obtain a variance in North Carolina, the applicant must meet or persuade the Board of Aldermen that they meet the 4 criteria, which I think is on page 6 of your agenda packet. Deb, is that correct?
Yes.
Okay. Those 4 criteria must be met to your satisfaction. The applicant has the burden of proof. It requires a 4/5 vote, not just a simple majority. And again, your vote must be based solely on the competent material and substantial evidence produced tonight. You can't have any outside thoughts or anything like that. It's got to be solely on the evidence produced tonight. So does anyone have any questions about that, Madam Chair?
Anyone have any questions? No questions.
Okay, the way we will proceed, or the order, we will first hear from staff, who will introduce the item. Then we will hear from the applicant, and then we will hear from any other party who's been sworn in that has standing to either speak on behalf or against this variance application. So unless there's any questions, it looks like everybody's been sworn in. By my count, that was about 5 people. So absent any questions, we'll hear from Ms. Hill, who will introduce the item.
The first, excuse me, the order of business for this hearing will be as follows. First, the planning director, Deb Hill, will present the staff report. Then we will hear from the applicants and their witnesses. Then we will hear from any opponents to the request. Parties may cross-examine witnesses after the witness testifies when questions are called for. If you want the board to see a written evidence such as reports, maps, or exhibits, the witness who is familiar with the evidence should ask that it be introduced during or at the end of his testimony. We cannot accept reports from persons who are not here to testify. Before you begin your testimony, please clearly identify yourself for the record. I now open the public hearing on case V-2402 and ask for testimony from staff. Ms. Hill?
Thank you, Madam Chair. Good evening, everyone. Case V-24-02, NDS Incorporated has filed an application on behalf of Jeffrey Keith Lucas and Judy Brown for 2399 Island Drive, tax map number 805-50. It's a combination of lots A and B in Section 7, Block 18A of the Winter Haven subdivision. Jeff Lucas is requesting a variance from the town's UDO Table 5-1, dimensional requirements. The property zone MHR to elevate, an existing 23 by 40 double-wide mobile home at 2399 Island Drive. It's a single-family residential, is the existing land use. It is surrounded by single-family residential. The site improvements are a 1999 double-wide mobile home, 2 wood decks and a shed, but I think you just have I think there's just a shed there now, I believe. 2 wood decks and a shed, that's correct. The size of the property is 3,364 square feet, or 0.077 acres. Staff's recommendation is to approve with conditions. The compatibility with the comprehensive plan, or the Camel Land Use Plan, as the town has adopted. The use is consistent with the existing land use map 10B as a single-family residential, and the future land use map 11A as high-density residential, which is intended to allow for the development on smaller lot sizes. This district allows for a wider spectrum of development options, and it's intended to allow for the location of modular housing and single-unit mobile homes. The parcel was created from the recombination of Winter Haven subdivision, Block 18, Section 7, lots A and B, that are each 25 feet wide and were approximately 87.5 feet long until shortened to 67.23, plus or minus, by the Island Drive right-of-way. Certificate of occupancy was issued for the 23 by 40 1999 mobile home on January the 22nd, 1999. The lot is non-conforming. The lot does not meet the minimum dimensional requirements of MHR, which would be 5,000 square feet. The 1999 post firm double wide is non-conforming, as it does not meet the required setbacks, which would be 20 feet from the front, 8 on the side, 10 in the rear, and it's not elevated above 12-foot BFE. And included in the staff report is Exhibit A, which I just went over. Exhibit B is the response to standards on page 2. Exhibit C is the public notice. Page 3, I've received no public comments and no agency comments. Exhibit D is the revision of Section 7, Winter Haven for Ward Realty by C.W. Blum, Jr., registered land surveyor, dated August the 6th, 1960. I had not been born yet, by the way. Map book 7, page 69 on page 4. Exhibit E is the legal description for lots A and B, Section 7, Block 18A, Winter Haven, from deed book page 275, which is on page 5 of the staff report. Exhibit 6 is the application agent authorization in the plat, and those are on pages 6 through 11. So also in the staff report is Figure 1, which is a aerial from Onslow County GIS 2022 of 2399 Island Drive. It's the one with the white roof with the red outline. And
Ms. Hill, you said Exhibit 6. I think you meant Exhibit F, the application, agent authorization and plat. Is that right?
Exhibit F, I'm sorry. Figure 2 is a photograph dated November the 20th of 2008 of 2399 Island Drive, the double wide from the Onslow County Tax Office. Figure 3 is a photo from the tax office dated 4/14/2015. And then figure 4 is an aerial oblique through Connect Explorer dated December 24th of 2021. And North Carolina General Statutes 160D-705 for variances when unnecessary hardships would result in carrying out the strict letter of the zoning regulation. The Board of Adjustment shall vary any of the provisions of a zoning regulation upon showing all of the following. The first condition is unnecessary hardship would result from the strict application of the regulation. It is not necessary to demonstrate that in the absence of a variance, no reasonable use can be made of the property. In the applicant's response was that the home is 4.5 feet up and sitting on concrete blocks. The owner wants to raise the house up on pilings to correct elevation for this area. He and the neighbors are concerned about damage that might occur from his property should there be a storm surge. And staff's response is orienting the double-wide longways the length of the lot like the neighbor's 64 stick-built 26 by 32 foot plus a 10-foot porch. The 67 feet is the shortest width, and minus 40 feet, which is the double-wide mobile homes length, leaves you 27 feet. So that would be, if you took 10 for the rear, that would leave you 17 feet for a front setback to the property line. Or conversely, if you did 7 feet from the rear and 20 feet on the front setback, either way, whether you spotted 3 on the front or 3 on the rear. And then with the 50-foot lot width and the 23-foot double wide's width, if you subtracted that, that would be 27 feet. If you split that in half, you would have 13.5 feet from each of the side setbacks. And MHR, the side setback is 8 feet. The hardship results from conditions that are particular to the property, such as location, size, or topography. Hardships resulting from personal circumstances, as well as hardships resulting from conditions that are common to the neighborhood or the general public, may not be the basis for granting a variance. A variance may be granted when necessary and appropriate to make reasonable accommodation under the Federal Fair Housing Act for a person with a disability. And the applicant's response is, owner wants to raise the house on pilings to correct elevation. Staff's response is that the parcel was created from a recombination of the Winter Haven subdivision, Block 18A, Section 7, lots A and B, which is included in Exhibit D, that are each 25 feet wide, were approximately 87.5 feet long in Exhibit E, until shortened to plus or minus 67.23 feet by the Island Drive right-of-way. Number 3, the hardship did not result from the actions taken by the applicant or the property owner. The act of purchasing property with the knowledge that circumstances exist may justify the granting of a variance is not a self-created hardship. And the applicant's response was, owner wants to have house raised up on pilings to correct elevation. Three. And then staff's response is a certificate of occupancy was issued for the 23 by 40 1990 mobile home on January the 22nd of 1999. The requested variance is consistent. Number 4, the requested variance is consistent with the spirit, purpose, and intent of the regulation, such that safety is secured and substantial justice is achieved. The applicant's response is owner wants house raised up to a correct elevation. Staff's response is, with the following conditions, to grant the minimum variance required, reduce the front setback to 20 feet, from 20 feet to 17 feet, to elevate the double-wide mobile home at or above regulatory flood protection, or 14 feet in AVD 88. And that concludes my staff report.
Thank you, Ms. Hill. Are there any questions from the board?
Real quick, on page 7, the response from the applicant, you have the date circled, and there's no date. What date was actually received, and was it received in a timely fashion?
The application was received on January the 11th. It's on the application there.
I see it now.
There you go. Yep. And the check was received for with receipt number 3917.
Ms. Hill, it said that the lot was shortened by the right-of-way. Do we know what year
I do
that
not.
occurred?
I do not.
It appears that many of the recommendation, or the report is set so that they would be reorienting the home, not based off of the current positioning of lengthwise running along Island Drive. Is that correct?
That would be my recommendation because currently they've got I think they're, based on the survey, it's like 1.5 feet to that side setback.
So if it were to remain in the same orientation that it's in now and elevated, it would drastically overshoot the variances on either side.
Certainly on one, it meets it on the right, on the northern side, but it encroaches about 6.5 feet. 6.5 feet on the southern side. Additionally, on the front, you can tell where the property line is. That deck goes right up to the property line.
Yes. Okay.
And
Thank you.
prior to them, when they rebuilt that deck, the stairs actually encroached within that right of way. So when they submitted an application to repair the decks, we had them pull those stairs back.
Thank you.
And with what they're doing now, by moving it, there's not going to be any, if they take the recommendation that you've suggested, then there won't encroach on anyone, and there'll be there'll be adequate room on each side and front and back.
That's correct. Where I had said that, they would have, 13.5 feet on either side, they could even shift it over all the way, one way or the other, to where that they had, met that 8-foot setback, and then have that extra room over on the side for decks and parking. Whereas now they don't have any room for parking
Right.
on their property at all. Any of the parking would be within the right-of-way.
So basically, all it would be looking for a variance for then is a 3-foot difference on the front setback.
That would be the minimum that they would need, and like I said previously, whether you granted the 3-foot setback in the rear toward that they would be 7 feet from the rear property line, and then still maintain that 20-foot setback on the front, I think would be ideal. Probably preferable to giving the variance on the front to try to maintain that front 20-foot setback. And I'll say in the aerial, when you go back and you look at the aerial in Figure 1, the house that's just to the south of it is a stick-built house, but the dimensions are nearly identical.
So you can see how much more room there is if they,
If they flipped it.
right. All right. Now we will hear from the applicant.
Madam Chair, before we go there, may I ask Ms. Hill some questions?
Sure, I'm sorry.
Ms. Hill, would you like to introduce exhibits A through F in the evidence?
Yes, please.
All right, is Mr. Lucas or Ms. Brown in the audience?
Mr. Lucas is present.
Mr. Lucas, do you have any objections to exhibits A through F coming into evidence? if he's answered, I can't hear him, I'm sorry.
Mr. Lucas,
He
if you
hasn't
could
answered
just
yet.
approach the podium, just briefly, thank you. And then correct the microphone.
Fix the microphone, please.
This is not something I do very much, so I'm kind of nervous and don't know, so.
Well, there's no need to be nervous, sir, and take your time. Ms. Hill just gave staff's presentation, and she went through exhibits A through F. They are in the agenda packet. I'm going to recommend we accept those into evidence, but you have an opportunity to object if you'd like, sir.
No, sir, I don't object.
Thank you. Madam Chair, I recommend we accept exhibits A through F into evidence as offered without objections.
Agreed?
And Ms. Hill, during your presentation, you talked about non-conforming. Just so we're all clear on this, you're talking about pre-existing legal non-conforming, correct?
I'm going to stick with the, I'll say that there was, I'm going to stick to the non-conforming, to how I have it written.
Right.
Just 1 second. And that there was a certificate of occupancy that was issued January the 22nd, 1999.
And the configuration, as far as the footprint, hadn't changed since then. That's my point.
It
Is
does,
that correct?
it does not appear to have, based on the 2008, 2015, and 2021 aerials. Other than, I guess there was a new deck constructed in the back and the deck in the front was reconfigured. But for the double wide itself, I don't believe has changed.
And just to make sure the minutes are clear, Madam Clerk, Ms. Hill referred to figures 2, 3, and 4, and they are contained in Exhibit B. Just if we have to reference this down the road, I just wanted to put that in the minutes. And then lastly, Ms. Hill, in response to Madam Chair's questions, you talked about, my words, not yours, but essentially the condition that staff recommends if the variance is to be granted. When you read the staff's response to criteria 4, do you recall that?
Can you repeat your question?
I'll say it in a different way. Staff's position on criteria 4 is that if approved, to add a condition to the approval.
May I put it in my own vernacular?
I just want to make sure that we know that that's what staff's recommending as opposed to what's applied for.
In the response to standards for condition number 4, that I believe that with that, if the variance were approved with that condition, then the requested variance would be consistent with the spirit, purpose, and intent of the regulation, such that public safety is secured and substantial justice is achieved.
Okay. I just want to make sure it's clear, Madam Chair, that as I understand it, that would be a condition to reduce the front setback from 20 to 17 feet. It's not clear to me that that's exactly what the applicant applied for. And Ms. Hill, feel free to comment on that.
That was not the applicant, that circumstance was not, or that proposal was not proffered in the applicant's application.
Okay. Just so we're clear on that, and the applicant needs to be clear on that if the board is inclined to consider that type of condition. Madam Chair, thank you. Those are all the questions that I have.
Thank you, Attorney. You ready?
I'm ready.
Okay. You've been ready.
Yeah, I lose sleep a lot this week.
Just state your name
Jeff Lucas.
and your address, sir.
And, home address, 109 Spring Lane, Lillington, North Carolina.
Thank you. Please proceed.
Just trying to do this to make sure that if we did have a storm surge, it's sitting on cinder blocks, it could wash out, that type thing. I know she's wanting to turn the house this way, which I've not objected to, but I also have a septic tank in the backyard. So I don't know if that has variance on anything either, because then I would assume if we do turn it, then it's gonna have to be hooked to the county sewer or whatever, which is a pretty expensive adventure.
I knew they'd be a fly in my ointment.
Is that,
And I don't know if they can add anything extra to it. Like I said, it's just basically, I'm wanting to try to get it off those cinder blocks, just in case we had a storm surge, that it would initially move the dirt, cinder blocks could come out,
yeah,
then my house is pretty much destroyed or could float into someone else's home.
right.
Becomes
It-
Noah's Ark.
Is the septic shown on exhibit?
It's not shown on any of the plats that I've seen.
Okay.
It's basically where the back porch is. The porch, we've never changed any sizes on those. I did add a set of steps from the left side to go down this way, but the original steps went that way. But when you go down the steps, the septic tank is basically sitting right there where the back porch is, to the right-hand side from if you're walking out the back door. And then I think my leach lines run the whole way through the back side back there.
So your request is to maintain it in the current orientation, or you're
I
willing
just
to?
I'm willing to do whatever is the best for the town. It's gonna be more expensive to try to turn it. I don't know if it would, and I don't know if y'all will worry about, but
I think
is it
ultimately,
gonna look funny, turned sideways? I mean,
I think ultimately it's your decision as to how you want to present it to the board and what you want to make the request. I think what Ms. Hill has presented is that there are less variance. We're only giving you a 3-foot variance on the front end if it's approved by orienting it this way, but if you do the other way, you're gonna extend, because of the plot lines, the property lines, you're gonna extend past the variances, and that would be more of a violation. You'd have less setback on the sides, is the way I believe I understand it. Therefore, I think it's showing less hardship, or I feel like if you keep it in the same orientation, that staff is representing that it's going to be more of a hindrance on either side, or more of an extension. What's your response to the request of, when did you find out about this change of orientation approval?
Probably when it,
when I read this email here
And what day was that?
2 days ago.
Okay, so 2 days ago, you were made aware that the recommendation was to reorient it, but you haven't had.
When I first got it, I didn't know what I was looking at, and then when I started really trying to read it, I mean, you know how it's, then I started saying, well, yeah, I understand what they're talking about now, because I'd had Johnny Williams do a survey, and he actually, for some reason, because I'd never noticed it before, but he had put it in there and did a drawing inside that, if y'all, we've got it in there.
That's the buildable footprint, yeah.
Yeah, and I never really noticed that he did that, but the part that I highlighted right there, I'm assuming he just did that showing what the true setbacks should be.
So I recognize that this exhibit is not yours. It was presented by, I assume, or representative from the company. Is that correct? Do you wish to have this piece of evidence submitted for our
Yeah, that'd be fine.
consideration? Okay. Then, Madam Chairman, I would recommend looking at exhibits. This would probably be Exhibit G, as in golf.
Yes.
Can Ms. Hill or Mr. Lucas or somebody identify what Exhibit G is?
Yeah, one second. Are you talking about making this Exhibit G? Before we make this Exhibit G, what it is this. But he's got, well, we can add it, since he brought it up here, Exhibit G, but you've got it in your,
Right.
here, it's that outline there.
It's Exhibit E. or
It's basically an enlargement of page 9, which is
Exhibit E,
the plot map.
Exhibit E, yeah.
yeah. It's a blow up of Exhibit E with the zoning setbacks for MHR highlighted with 20 feet in the front, 8 feet on both sides, and 10 feet in the rear, indicated by a dashed line and highlighted in yellow.
Did you say it's a little, Exhibit E or Exhibit D? I'm sorry.
Exhibit G that the applicant has submitted to be
I
included
got that, but
is,
the blow up of
it-
which other exhibit?
it is a blow up of Exhibit E with the zoning setbacks for MHR highlighted in yellow. Oh, sorry.
So I assume you don't have any objections to that coming in evidence?
No.
We have staff.
Uh,
Madam Chair, I recommend we accept that into evidence without objection as Exhibit G.
All in favor? It's good for me, yes. Yes, absolutely.
Now, this, again, appears to be the enlarged plot map that was presented in the
Yeah,
staff
it's
report.
basically the same thing there, but just looking at it before when he did, I didn't really pay attention that he had put those, it just didn't never occur to me until I started looking at what she had presented, and then I said, well, he had already done this but I don't know if that was just showing, I don't know what reason he did it, it was just there, that's.
It's actually a requirement whenever you're doing a site plan to indicate the setbacks on a
Okay.
plat. But do not feel bad for not noticing it before, because I didn't notice it, I don't think, until you just brought it up, and I've been a planner for 25 years, so don't feel bad.
I,
Thank you for bringing that to my attention.
So you can see then from the enlarged plot map that essentially the current footprint extends outside of the dashed line, which is where
correct.
the house,
Yeah,
the decks,
it's
and all must
on
be
the
within.
left-hand side, there's very minimal. On the right side, you have close to the setback. But, off the front and the back, when they, and I didn't realize that they had, the state or whoever had took 25 foot of the property. When you go and pull up, there were some mistakes that were made on my end that I should have done more due diligence as far as the road, you know what I mean? They took 25 foot of your road, so really you didn't own, I just didn't know all these things at the time, and so.
Can I just make a comment?
Please.
I just want to respond to that. On your deed, that description that I got for the 87 feet, I don't want to, in Exhibit D, that came from your deed where it does the legal description as 87.1 feet and then 87.8 feet.
Yeah.
That was out of the legal description for your property.
And then, like when I bought it from Clay, he didn't tell me it was non-conforming. These are all things that I learned afterhand. And, you know, that, I know a lot more now than I did before, but, you know, that's water under the bridge, so.
Right, right. And in the language of that deed, I will say that it says title to the property here and above described as subject to the following exceptions. And the first one is rights of way and easements of record, if any. So they're referring back, they're kind of covering themselves. And that's one of the things, right?
Because I noticed, you know, if you take that and you go look down the road, there's a whole lot of them that are sitting in the same situation that I'm sitting in, but, you know, but.
Well, your neighbor more so.
Yeah, well, just any, you know,
Right.
when they took that, they kind of messed a lot of things up, but there's nothing
Right.
I can, you know.
Right. And if I could can I make one more comment?
Please.
So right now, it's, you mentioned that it's on cinder blocks, but it is also anchored, right?
Correct.
So it is anchored. And so my thought is if you're going to put it on what typically is considered a permanent piling foundation and elevate it, because right now it's anchored and it's on cinder blocks. It's considered personal property, right?
Correct.
So you're going from personal property to actually real estate by putting it on an engineered piling system and elevating it. And so my thought as a planner was from taking it from that personal property anchored on cinder blocks and then elevating it, let's make it fit as best as we can.
Because I would rather it be a compliant lot, because
Yeah.
if I was to ever do anything with it, then I'm gonna run into issue, because some people are smarter than I am. They're gonna say, well, it's non-compliant, it's the, you know,
Well, and by it being as compliant as it could be, would be actually helping to protect your investment.
It would have more resale value.
you're correct. And, you know, that's things you know, that I'm not objective of, I think it looks nicer turned the way it is, but if it needs to be turned, you know,
Right.
and put into where it is a compliant lot, that's, I mean,
Well, I will say that you know, if you look at, and I think if the board will look at figures 2, figures 3, and figures 4, from what it looked like in 2008, and I think you bought the property in 2000?
yes, ma'am.
So you bought the property in 2000, and here it is in 2008, and it's boarded up, and we've been through a few hurricanes since the time that you bought it until today, and then what it looked like in 2003, and then I think it was in 2021, probably after Florence, you'd done some repairs and had a metal roof put on and I think you had new siding done.
Yes, ma'am.
Correct me if I'm wrong. And you also had the windows replaced. So
Yes, ma'am.
And you had your decks repaired.
Yes,
So you've put a lot of investment into trying to hold on to what you have here,
yeah,
right?
yes.
Okay.
I guess my concern for you is understanding now that the recommendation would be, unless you want to ask the board to keep it in the same orientation and us to consider that, or if you're willing to accept the potential recommendation of orienting it 90 degrees in a different way.
Yeah,
Again, you
the
said,
only question I would have on that for the board would be, if we turn it, we're making it a compliant lot. If we leave it, if we leave,
I think the lot size makes it non-compliant. You can't make the lot any larger.
Right.
Ms. Hill can correct me if I'm wrong. I think what we're talking about is the variance or the overages, over the lines, the invisible lines that you can build on. You're not crossing over the property lines, the real property lines. You're crossing over the variances on either side, the front and back.
Correct.
And as you can see in your,
The setback lines.
correct. So the exhibit that you presented shows clearly the home is outside of the setback lines now. And because it was like that, and it was previously approved, it's good like it is. So if it stays like that, you don't elevate it, it stays where it is, the board doesn't consider anything.
Correct.
If you want to raise it,
Yeah,
then we
yeah.
consider, okay, if it stays in that footprint, the extension over the offsets is more egregious than if you oriented it the other way. But you're now being brought into this 2 days prior and asked to try and figure out, well, how much more may it cost me in doing that? And that may be something that your contractors may be able to answer for you during this hearing.
Yeah, and then basically another question I have, like, if I do that, how would I do my steps? Would I be able to have a porch on the front anymore? Those are all questions that I would, like
And
to.
your septic sink setback.
Yeah, the septic's the
Yeah, because, well, if you turn the house, septic's,
gone.
it's gone. You're forced to go that way. There's no ifs, ands, or buts on that.
And that
So that's a-
probably answers the question why they put the double wide where they
This
did to
way,
begin
that-
with. And staff at the time signed off and issued a CO with it sitting on, and maybe
But
when
see,
they signed off on it, maybe you
Was
had
there
another
a
20
home there
feet.
prior to this home?
I don't know.
I see, I don't know either, so
Yeah.
I don't know if that septic tank was there originally and then they put another I don't know those answers on that.
Well, it could be that it was 87 feet long at the time that they issued the CO. I don't have that information.
Right,
And then between the time that they were issued the CO and today, the
Things have
NCDOT
changed. Yeah.
expanded it right away.
right.
You know,
Yeah.
or
But I don't know how they would have changed the left and the right on it, you know what I mean? Because evidently they allowed them to break it off between that trailer and Pam's home and only being a foot, 2 foot. I don't know all those answers.
And to be honest with you, in 2000, in 1999 and 2000, and Kate's here, and I think that she can attest to the state of records in inspections prior to 2000, 1999, 1998, 1977, when the staff went, or whenever the town went through Fran Floyd and Bertha, and a lot of inspection records presumably were scattered, windblown out into the wetlands.
Right.
And carried throughout. Back whenever the town was in a mobile home, from what I understand, and not in the building that we're in now, I believe. So it could be that they did have a public hearing on it and they were granted a variance, but I have no documentation on that. And so when you ask me, is it legal non-conforming, I can only say non-conforming because I have to go by what records that I saw when I went through the folder and what I have available.
Right,
I wasn't here, so I can't make a judgment on whether somebody did something properly or not. All I know is that double wide received a certificate of occupancy from the building inspector that worked for the town of North Topsail Beach.
right.
Okay?
No,
That's all I know.
right. And that's about all, they allowed it then, but things probably have changed since then that they might,
Well, if you came in today and you said that you wanted to do that, I'd say, well, you got to go to the Board of Adjustment and get a variance because I can't sign off on it. And you'd be right where you are today.
Right. So,
We'd be right back here. But that's the beauty of the system is I only have administrative authority, right? I can't hook up my buddies. I wish I could. But I can only sign off on what the book says I can sign off, and then anything other than that, it comes out into the public, out into the fresh air, out in the lights, and then these good people get to make that
judgment.
that decision. So.
Mr. Attorney, based off of the fact that he's only been given 2 days, can the board grant him an extension to investigate the cost and come back and say, yes, I'm willing to accept, and then us proceed, or should we continue to proceed with the evidentiary hearing, make a decision based off of staff's recommendation of orienting it that way? If we approve it, does that change his options, his ability to make whatever changes or withdraw any changes that he would like to make? How would it impact him?
If you were to issue a variance tonight, with the condition that staff recommends, that would not preclude the applicant from coming back at a latter date saying, I'm applying for a variance without that condition or whatever, and then he could make the case for that variance. He's not stuck, if you will, for lack of a better phrase. I guess that's not a very legal term.
We all understand.
He's not stuck with this variance. He can, if he were to be granted the variance with that condition, he could elevate and reorient the house pursuant to that variance. He doesn't have to. He could say, well, I don't want to do this, or it's too expensive, and come back.
Or in theory,
Conversely,
please.
Conversely, though, if the board is inclined to want to hear about the financial implications of that condition, theoretically, we could recess this hearing and reconvene it later. I think that was the thrust of, or at least the initial part of the question.
Yeah.
I agree. I also don't want his contractors to have to come back to another meeting. So if Mr. Lucas, you want to think about it, we can continue a little bit as
We could take a
we're going
recess,
through.
and he could think about it.
And then after they at least present their information so that we could consider it, should there be something later down the road.
I'll confer with them and go from there.
Okay. We'll have a 5-minute recess. Back to order. For Brian.
There he is.
Thank you. Would you like to continue, Mr. Lucas?
Yes, ma'am.
Thank you.
After conferring with your contractor, have you want to make any
We wanna go ahead
recommendations or
and do the
statements?
Do the variance, yes. We want to go ahead and continue, go ahead and do the variance.
Okay.
And I don't want to put words in his mouth. Can you expand on that? Do you want to help him, John?
Would it be better if he might answer that better than that?
Go ahead. Yes, please.
Well,
Well, John,
maybe I can help.
well, John
Brian,
sworn in.
let John help. John was ready to, John knows because we were outside talking.
John's sworn in, so he's another witness.
Good evening. My name is John Cassidy. I'm the owner of Pilings and More. Been doing piling work, raising houses, moving houses, almost 30 years. Again, Mr. Lucas's house is on cement blocks. I've never, ever put a house on cement blocks. I wouldn't even build a deck on cement blocks. And Mr. Lucas didn't realize when I went and looked at his property that he was on cement blocks. I said, man, you got a liability here. I said, any type of storm like a Hurricane Fran, that house is going to go like a bowling ball right through the neighbor's house. So anyway, with the board, I would strongly recommend that you guys try to help Mr. Lucas in getting this thing elevated and get it secured on pilings and make it safe for everybody in your community. But getting back to talking about, Mr. Lucas is willing to twist the house, move the house, get it surveyed, get it to where we can fit the house on the property, and ask for the 3-foot variance, I believe is what it would be in the very back, and go from there. And
Given the discussion of reorienting it, do you foresee any issues with the septic field? And I'm just trying to spitball into the future to make sure we understand what sort of issues that may bring to
Yes, sir.
the project.
I went by there today and I just stepped it off just to see where a septic tank. And Ms. Hill, we're gonna get that verified. I believe we gotta stay 5 feet away from the septic tank.
Yeah, 5 feet.
5 feet. The living quarters. And I believe the house is gonna fit the way it is after we twist it. I think the septic tank won't come into play.
So you think you can make it work based
I
off of the
believe so.
reorienting?
Yes, sir.
Okay.
But we'll get that surveyed and get a plot forwarded to Ms. Hill showing where the septic tank is, and to make sure that we have adequate room before we turn in our paperwork for permits.
Do you think it would be more advantageous, considering that the septic tank is somewhere in the back, to do the variance in the front?
Yes, that would give Mr. Lucas, that'll give us some room to,
An extra 3 feet could make
Yeah.
a difference there.
exactly. And that way, if there's any issues with the septic tank that gotta be dug up for some reason, that'll give the septic tank contractor more room to do their work.
Because if you push them all the way,
Yeah.
yeah, if you push them all the way to the back, then I think that we're exacerbating the septic tank issue. But if you spot them 3 feet on the front, you're giving them a little bit of elbow room on that.
So your understanding is if the Board of Adjustment approves with the recommendation that it be oriented, that we would be approving it, at this point, I believe, the 3-foot variance in the front, and if you wanted to deviate anything outside of that, I believe you would have to resubmit.
Yes, sir.
I just want to make sure we're not painting you into a corner, giving you enough options that you all can
And I believe the
investigate.
power lines as well are on the other side of the road, so we're not gonna encroach into any high tension wires with Jones Onslow.
I have a question. If we just recess and then bring this back when Mr. Lucas has all of his information that is now that he knows what we're looking for, is that more advantageous than him, us making a recommendation and then him having to need another variance? Would he have to reapply and repay the fees and all that again?
I would work with him on that, and we would just, it would be resubmitting the variance because it turned out that it did not work. But if you grant him the variance and it does work, then he's off to the races.
Right, but if it doesn't work,
If it doesn't work, then we'll just come back. I'll work with him.
okay.
So you'd work with him so that he wouldn't have to pay another fee. So if we make a decision based off of the variance with a recommendation of reorienting it with the 3-foot offset, the 3-foot variance on the front end, you could proceed, make sure everything looks fine, and if you want to change it, then you would have to make the recommended changes. I believe she's saying that that won't incur another application fee.
It would be a continuate.
We
just
would
bring
then
this
have to
back.
re-meet to discuss that, whatever variance outside of the 3-foot on the front end offset. And then well, I don't want to speak to say you wouldn't have to come back. I know you gentlemen probably would
Right.
prefer to be other places and sit in front of
So-
us, but.
Right.
Is your recommendation a continuation or?
No, my recommendation
Okay.
is to grant
Alright.
grant the variance
Okay,
as written in the report to reduce the front setback from 20 feet to 17 feet.
Can I add one more thing?
yes.
And another thing, we would like to proceed as soon as possible, because by the time we get engineering, we don't have any engineering yet, and get our permits, or rest of our permits, get the house raised, we're gonna be getting in hurricane season. So that's the last thing, we want to have the house elevated, and there's a category 3 out there. Mr. Lucas is calling us saying, how's things looking? Well, yeah, been there, done that, so that's not,
It wouldn't be the first time, John.
yeah, that's not fun to go through.
I was gonna-
Anybody else have any questions for Mr. Lucas or Mr. Cassidy?
You were talking about the scheduling. If you don't mind me asking, I'm not trying to paint you into a commitment on how long it would take, but how long do you anticipate the project like this would take to?
We've had my engineer, Boyd Adams and company, already go out and look at the site. Nothing's been done on paper yet, because I advised Mr. Lucas, don't pay for engineering yet. Find out something we can't do. But my engineer's on go. He's waiting on a phone call tomorrow, and he's got him pretty much on schedule. So I'd say within a few weeks, we'll have some engineering. And then we'll proceed with permits and get the ball going.
Thank you.
Thank you. Attorney Edens, do you have any questions for?
I just want to make it clear that if whatever happens tonight is a variance being issued, if what they propose to construct is different from that variance, they will have to come back before the board to get another variance.
Is that understood? Everybody understand?
Yep, yes, sir.
Thank you very much.
All right.
Mr. Attorney, I know we kind of switched from the owner to the contractor. Did you have any questions that you wanted to ask or clarify to the owner?
I have no questions. I just want to make sure they understand, as I just stated, that
Did I just ask that?
and I don't want to put the cart before the horse here. If the board's inclined to grant a variance, if that turns out to be logistically not possible or feasible to do, they'll have to come back.
Right.
And Mr. Lucas, you're aware of that, is that correct? And you're nodding in acknowledgement, thank you.
So no one has any questions? Okay.
I'm sorry, I actually do have one question for Ms. Hill. Were notices or feedback allowed for the neighbors of adjacent properties to, on this matter?
The sign was posted and all the public notices were made as is required. And I received no comments either from the public or from any agencies.
Thank you.
We'll now hear from people opposing the request. there anyone who wishes to speak? No one's come forth. Does the planning director have any further comments?
No, ma'am.
Does the board or any other parties have further questions of staff?
No?
Okay, discussion from the board.
I think, obviously, this was thrown at you 2 days ago, and it's difficult to try and picture it and figure out exactly how it's oriented. But I think we've gotten assurances that what the board is now considering, unless you wanted us to consider something different.
You're supposed to be talking with us.
Oh, I'm sorry.
That's good. Go ahead.
I just want to make sure that he seems to understand that.
Right.
I'm
We've
good.
asked him several times.
I'm good with considering the 3-foot variance. I just want to make sure that he understands that it's the 3-foot front setback variance that we would be approving only. And the attorney has also told him that as far as anything deviating from that would have to be different.
Correct.
I hate for people to have to come back, especially the contractors. I think reorienting it is the least egregious or least overages on the offsets all the way around. And I think given the current standards and current requirements, I think that this is a good recommendation of a condition.
Okay, are we ready for a motion?
Anybody else want to make a comment or a question?
I'd like to make the motion that we grant the variance, but changing it to a 3-foot adjustment on the front or street side of the structure.
I second it.
And just for clarification, that would be a motion to grant the variance with the condition that the variance will be a reduction of the front setback from 20 feet to 17 feet. Is that correct, Ms. Hill?
Yes.
So there's a difference between a condition and the variance itself. What we're doing here, based on the motion I just heard, is granting the variance not as requested, but granting the variance with that condition that we discussed ad nauseum.
Yes.
Right.
Correct.
Correct.
Mm-hmm.
Can I get a second?
I said,
Oh, I'm
I
sorry.
second it.
Seems to be another question, I'm sorry.
We have letters from the neighbors. Yeah, all supporting this, saying they don't want their house,
Oh,
his house to go into their house.
So even, Mr. Attorney, even though there other documents are coming in after the motion has been made, is that still acceptable for us to move them into
Well,
exhibits?
I mean, I would caution you and admonish you to at least acknowledge, if not consider, the fact that those letters or whatever has just been ended up are technically hearsay. Those people are not sworn in and they're not subject to cross-examination. I think that the fact that this was a properly noticed variance hearing, and according to Ms. Hill, she hadn't received any negative feedback, served the same purpose as I anticipate the gentleman's proffering those letters for, so.
I'd be willing to accept them for what they are, as letters from the neighbors. One of them certified. And
Madam Chair, technically, those are hearsay documents. If I heard you correctly earlier, you asked if anyone was sworn in that was there in opposition.
that's correct.
Apparently no one is.
No,
So
no one
if staff,
came forward.
if staff has no objection to those coming in, I'm certainly not gonna stand in the way. Technically, they are hearsay documents. Those folks are not here for you or the applicant.
one person is.
To ask questions of. But if they're tendered and there's no objection from staff, I'm not gonna stand in the way of them coming in.
Ms. Hill?
There is one gentleman that submitted a letter that is here. But he was not sworn in.
He didn't submit the letter.
Oh, I'm sorry, I misunderstood.
I'll come up there.
Oh, I'm sorry, I
Okay.
misunderstood.
Now, the other ones are all adjacent members behind,
Right,
adjacent,
sorry.
adjacent property.
Yeah, sorry, I retract my statement, sorry.
Okay.
Okay, we have a
All right,
motion on
we have
the
a
table.
motion and a second.
I seconded it. It's
Correct,
to
okay.
create- Or is it to accept?
Clerk, please call the roll.
Ms. Kozlowski,
Aye.
Mr. Durazio,
Aye.
Ms. McLeod,
Aye.
Mr. Morse, Mr. Malcolm,
Aye.
Thank you. Okay, we-
Congratulations. I'm gonna keep my fingers crossed and hope that everything works out and we don't have to come back. I'm feeling pretty optimistic about this. I don't know why. I'm pessimistic by nature, but I'm feeling good about this.
Thank you very much, gentlemen, and if you have any questions, I'm sure Ms. Hill will be able to guide you in the right direction, and we hope we don't see you again.
Thank you for your time.
Okay, continue with our meeting. Item 5, discussion about training.
Okay, Brian, since you are an attorney and this is your field of expertise, I sent you the presentation. If you want, I would certainly welcome and enjoy if you wanted to kind of present this, like the next 10, 15 minutes, going over the highlights.
I just got this afternoon, Deb, so I haven't gone through it all. I mean, I briefly reviewed it. It's essentially kind of what we go through in the preamble every meeting. I'm not comfortable making a presentation on it because I haven't read every slide yet.
Okay.
Deb, can you do that?
I can, and I'll probably stumble through it as well. I know that Brian's a lot more polished than I am, so.
That's okay.
So just, and mine's probably a little bit more folksy, which is why I kind of printed it off. I had gotten this from, I don't want to disclose like the town and who all did it, but I certainly wanted to give them credit for doing so. But for the Board of Adjustment, just who we are, what we do, types of Board of Adjustment cases, and best practices. And this, it was coincident. This is another small town where they have members of a planning board that are appointed by the town board, and they hear cases in groups or panels of 5 members with 2 alternates. They have a chair. They also have a ETJ member, which we do not have ETJs. And members are selected on cases based on a rotating roster. So but for the decision-making, legislative decisions are set policy, ordinance amendments, and have broad discretion in decision-making. These are made by, legislative decisions are typically made by your local governing board, and in our case, the Board of Aldermen. There's quasi-judicial decisions that are made by the Board of Adjustment. There may also be quasi-judicial decisions that are made by the Board of Aldermen as well. So for administrative staff, and I mentioned this earlier, we try to make objective decisions, and but we certainly have very limited discretion, whether it's with building permits, zoning permits, the day-to-day processing of applications. And whether we're the local government or the Board of Adjustment or staff, we're basing our decisions on North Carolina general statutes, sometimes admin code, our uniform development ordinance, rules of procedure, and the Board of Adjustment, as you know, is quasi-judicial. You listen to variance requests and appeals from my administrative decisions. Applications are skip that
You can
one.
skip that one.
Yeah, I was like, I knew that was going to catch me. Let's skip that one. Hearings are formal. Chair provides, would swear in witness and provide evidence, and you have deliberations and then voting. This is
Tim, if you want me to, I'll go ahead and kind of wing it. I didn't prepare this PowerPoint, but I can walk through it if that's what you like.
well, I think it's good because you have that attorney brain.
Okay.
It's more of a
I don't
discussion.
know if that's good or not.
It's a good discussion to have as far as reminding us of what our functions are. I mean,
Sure.
the final point on there that I did not realize that we're the final decision makers and that ultimately the only appeal is to the Supreme Court of North Carolina.
No, Superior Court.
Oh, Superior, sorry, I read it wrong. Thank you.
It's okay. Well, it could go to the Supreme Court because if someone who has standing disagrees with a variance decision or an appeal of an administrative decision that the Board of Adjustment makes, their next step is to the North Carolina Superior Court, which for North Topsail Beach is in Onslow County. And what that court does, they kind of sit as an appellate court and they look at the record. And that's why I was trying to be somewhat meticulous with Madam Clerk as to what we were doing and identifying the exhibits and all that, because it's not a do-over when you appeal it to Superior Court. The Superior Court essentially looks at the record, and the record is largely comprised of the minutes. These days we have Zoom recordings. Sometimes we will have court reporters, but I would say 85% of the time it's the minutes of the meeting, which include the exhibits. And then the Superior Court judge, he or she looks at whatever the standard is. In this case, we were looking at the 4 criteria and determines whether whether they call it the whole record test. And essentially, technically, it's whether there is any way this whole record supports the board's decision. And if the answer to that question is yes, then the Board of Adjustment is affirmed. If the answer to that question is no, the Superior Court can either reverse or send it back to the Board of Adjustment for additional findings. I will tell you that over the last 3 or 4 years, I've seen several cases of the Board of Adjustment being overturned for various reasons. I don't want to get into all of that during this conversation. Suffice to say that it's important that we have a solid record that the Superior Court judge can look at and say, it was based on these facts and this evidence that the Board of Adjustment ruled the way they did. But to your point about the Supreme Court of North Carolina, if either party after the Superior Court rules does not like that ruling, then the next step is the North Carolina Court of Appeals. And then under certain circumstances, if you don't like the Court of Appeals decision, you can appeal it to the North Carolina Supreme Court, but that is not an automatic appeal. There either needs to be a written dissent at the Court of Appeals level, or you petition for what's called cert, and then the Supreme Court of North Carolina would have to decide whether this case has statewide significance. There's other criteria. I'm trying to summarize this, though, that they would take that up.
Thank you.
Absolutely. Going on to the next slide, this is kind of what we talked about in my little preamble about due process. This particular slide refers to the statutes and the Board of Adjustment Rules of Procedure. The notice requirements, which Deb hit on briefly during the hearing. The opportunity to be heard is what we just conducted, was a quasi-judicial hearing. And then this impartial decision makers is what we were talking about at the beginning. And I think there's another slide here that'll get into that deeply, but the decision must be based on the evidence, the record. It's kind of hard for me to follow this slide because I didn't write it, but we just did all this. Witnesses were sworn. We already talked about the right to appeal. The next slide, life cycle of a Board of Adjustment case. The applicant files an application, and then as we just kind of saw this in real time, staff calendars, the hearing is open to the public. The participants are generally, obviously, the board itself, a staff member, and then the applicant, and then all those with standing that want to provide testimony. Oftentimes, the town attorney will participate. That's not 100%, and it's not required by statute. But I would say more often than not, the town attorney is involved in some form. The board issues the written decision, but generally the staff member or the town attorney will draft that decision, and that decision will be based on the motion and vote that occurs during the hearing. I'm moving on to the next slide. Are you guys looking at this as in paper copy?
Yes. Yep.
Okay, because I've got it up on a different screen.
Right.
The hearing is open to the public. We talked, we just went through all this. Type of vote required for a variance is 4/5. This particular variance was unanimous, but an appeal from a staff member's decision only requires a simple majority. And sometimes when you have only 4 members show up for a Board of Adjustment meeting, it can be complicated because we have to get the applicant to agree that since a 4/5 vote's required, and I think this happened last month, didn't it?
Right.
Yeah.
It did.
Yeah. They have to agree and acknowledge and agree that in order to get a variance, if there's only 4 members present, it's got to be essentially a unanimous vote of those 4. The determination of parties with standing, that's something generally the town attorney will do. I will tell you that unlike Superior Court, Board of Adjustments, and the Board of Alderman meetings, we are much more liberal as to allowing people to speak. I've never seen a case being turned over because you allowed someone to speak that didn't have standing, although you can get cases turned around where you don't allow somebody to speak who did have standing. Standing essentially means that you either are the applicant, the governing body, or a party who is going, or allegedly is going to suffer special damages that are distinct from the rest of the community. Generally, the geography dictates that the closer you are to the subject property, the more likely you're going to be able to, allege special damages. Otherwise, somebody from Idaho could come to North Topsail Beach and say, hey, I don't like this variance. And you can understand the public policy reasons why you wouldn't allow just anybody and everybody to contest these things. It's got to be somebody who has essentially skin in the game.
That's what Facebook is for.
Number 6 there, swearing the witnesses, we did that. And we just went through staff report, applicant, there were no people in opposition, therefore there was no rebuttal. You guys did deliberate. You guys did have a motion and a second and a vote. Again, the decision will be reduced to writing based on your motion and be presented to Madam Chair for her signature, and then you close the hearing. Conflicts of interest. I don't know how deep of a dive you want to get into this, but essentially, if you can't be fair, you should not participate, and you should recuse yourself. The number one conflict of interest is a direct financial interest in the subject matter. Few examples: if you've got a competing business, this one was a residential, but if it was a commercial one, if you have a financial interest in the variance, say you were the engineer for this property or the contractor for this property, obviously, if the variance is granted, that affects you financially, or not granted affects you financially. So it would be your duty to identify that and recuse yourself. Ex parte communications is what we talked about earlier. Those are communications outside of the context of the hearing where you talk about, you can ask general questions like, is the hearing still scheduled, or when's the agenda packet going to come out? Things of that nature. But if you start getting into the substance of the application outside of the context of the hearing, that's something you need to disclose or required to disclose. And the whole concept there is the applicant is entitled to a fair and impartial decision maker who bases his or her vote on the evidence. Well, if you have all these extraneous conversations that are shaping the way you see this application, the applicant's entitled to know that and ensure that you're fair and impartial. So that's why those questions are asked at the beginning, and that's not just for the staff. If you happen to know the applicant or the applicant's cousin or whatever, and sometimes this happens all the time, they'll call up, especially at the Board of Alderman level, they may call you and say, hey, I've got this variance coming up. I really need this for A, B, and C reasons. And that would be inappropriate too, just like talking to staff outside of the context of the hearing. And the concept there, again, it's really simple, although as lawyers do, we have 10 pages of PowerPoint, is there's 4 criteria they have to meet. They have to prove that to you to at least 4 out of 5 of you. And they have to prove that to you with competent evidence during the hearing itself. By way of example, say there were people here tonight that were against this, and somebody hands up a stack of neighbor letters saying, hey, all my neighbors are for this. Well, there's no way to verify whether, even if they're sentence certified, whether those were actually written by the neighbors, if the neighbors have all the information, are aware of all the ultimate implications. And that's why they're required to be there and subject to cross-examination. Fortunately, tonight, we didn't have anybody in opposition, so that didn't really come up. I also asked about familiar business relationships. You can see that there on that page. If someone's related to you or you're a business partner with someone, that would tend to suggest, despite your best efforts, you couldn't be fair and impartial. You might already be leaning in favor of them. That's why we ask for those disclosures at the beginning of the hearings. My next slide reads grounds for recusal. I think I just went through all of these. There's a second slide on recusal, but we just went through all of those. My next slide is evidentiary hearing order proceedings. I'll be happy to go through that if you like, but we essentially just did all of this.
Yeah, there's a public records and communication. I kind of skipped forward where it says all emails and texts in your role as a Board of Adjustment member and Planning Board member are subject to disclosure to the public. You should not discuss the subject matter of a Board of Adjustment case with other Board of Adjustment members outside the hearing. You should not discuss subject matter of the Board of Adjustment, or actual or potential, with parties who will come before the Board of Adjustment. And that gets to that ex parte. And hearings are open to the public, like you said. Most of this really is just a repeat. The one, and it's kind of common sense, but it was talking about, if I see it now, the job of Board of Adjustment members in a nutshell: show up prepared, disclose potential conflicts of interest, ex parte communication, special knowledge of the case, which we do in every meeting, listen carefully with an open mind, weigh evidence to determine the contested facts, apply relevant standards to the facts, and I think that comes hopefully through this staff report in the response to standards. I think might help that relevant standard to facts, determine if the burden is met, and then make findings of fact. And that to me, I think that boils it down in a nutshell. But I think the job that the Board of Adjustment, that each of you serve as members of the Board of Adjustment, is really a very serious and critical service that you provide to the town as a pressure relief valve for what can be very contentious land use decisions. And sometimes it's very difficult to make decisions when you know that these folks are your neighbors, and everybody knows everybody. It's it can be a thankless job. Certainly you're not getting a big paycheck at the end of the week for coming here and spending the evening, but it is taken very seriously, and it can have great impact. And like Brian said, some of these decisions, interestingly enough, go to Superior Court and wind up going to the Supreme Court of the United States and become federal law, not just in North Carolina, but throughout the country. And that's where you get a lot of very interesting, very, very interesting opinions. And even on the Supreme Court, not all those members of the Supreme Court agree, right, Brian? You've got the, you've got, they'll write, you'll have a judge that writes the dissenting opinion. So the important thing is that when you vote, how you see it and how you interpret, the information, that the facts that they're presented to you. And if four of you vote one way and one of you votes the other, then as long as you feel in your conscience that you did your job, then you know what? You voted correctly. Right? So that's...
Yeah, well, you voted correctly if you base your vote on if you have an understanding of the criteria. And if at any point in any of these hearings you don't understand the criteria, that would be the time to ask a question. So if you understand the criteria and you feel that the applicant has met or not met their burden and you vote accordingly, then that's an appropriate vote. The way you will be judged, if you will, is that, like I said, the Superior Court will look at the whole record and basically say, based on this record, is it plausible they could have reached this decision? And if the answer is yes, then they'll affirm you. If the answer is no, they won't. Again, I try to keep it simple. If you just think about what you would want, if you came before a Board of Adjustment and what your neighbors would want, it's kind of a twofold, two-pronged analysis. You bought some property, or for whatever reason, you can't do what you want to do. You did not create the situation, and it's creating a hardship. And what you're doing is not creating what you propose to do is not going to create a safety risk or anything like that. You would want the Board of Adjustment to look at this from a unbiased point of view and say, okay, is what they're proposing reasonable? Even if it is reasonable, do they create this situation? A lot of times you'll see people wanting to put in, this is more inland than at North Topsail, but wanting to put in a huge pool. They can put in a pool, but they can't put in as large a pool as they want. I'll give you an example. So you have people that want to put in this huge pool, and they just say because it's nicer. Well, I mean, I would suggest, based on my hypothetical, that doesn't meet the criteria. If they can put in a pool, they just can't put in as nice a pool as they want to. Now, if someone is, has a disability and they need a larger pool deck to accommodate their wheelchair or whatever, that's a complete different analysis than it is pure recreation, if that makes sense to you. At the same time, that's from the perspective of the property owner. You want somebody to be fair and unbiased. If you're 5 doors down and you have the same lot size, let's just say the same roughly footprint of your house, is it fair that somebody 5 doors down can build a bigger pool than you just because they want to? Those are the type of things that you would have to consider in these type of hearings. And that's on the variance side. On the appeal from a staff decision, it's essentially, you have to look at the ordinance and say that staff construed this ordinance correctly. And Deb, that's probably a longer conversation than you want to have tonight. But since we just went through a variance, and variance is what we see most often. So if you come into it looking at what they're asking for is to vary, that's the root of the word variance, to vary from our code of ordinances, then they have to meet that criteria. And they have to prove that they meet that criteria in the context of the hearing, not outside of the hearing. And if you have any skin in the game or any preconceived notions about it, then it would be your duty to identify that. And ultimately, if you can't be fair and impartial, recuse yourself. So that's kind of a whirlwind of me going off of somebody else's PowerPoint. If y'all have any questions, let me know. I mean, I could talk about this stuff for hours. But it is a very, very important function that you guys serve.
I do have a question.
Yes, ma'am.
So what if one of us comes up and we need a variance and we all know each other? What do we do then?
If I was the applicant's attorney, I would, obviously, whoever's applying for it, could not sit on that board of adjustment. And then if I was the applicant's attorney, I would ask each one of you if you could be fair and impartial. If I was against it, that is, knowing that this is one of your fellow board members asking for this variance. I mean, I would drill down on that deeply if I was, excuse me, I said if I was the applicant's attorney. If I was somebody in opposition to that, I would ask. But regardless, it would still be the board's duty to say whether they're tilted one way over the fence, either way. I mean, you got to start with a clean slate. I mean, you know, and we're all humans. We're not robots. But if you know in your heart, I don't care what the evidence is, I'm either going to grant this or deny this, then it's your duty to disclose that. Does that help?
And the request to be recused? Brian?
Oh, there's no question that if you're the applicant, you couldn't sit on. I mean, you have a direct financial. That's question one. You have a direct.
No.
Financial interest in it.
No, I mean, if you had a fixed opinion, you would disclose that you had a fixed opinion and then request to recuse yourself.
Yes.
Right.
That's your duty. If I was involved and I heard that statement, whether you asked or not, I would direct the question to Madam Chair in this case and say, Madam Chair, board member so-and-so can't be impartial here, and I would recommend a motion for recusal. But the ideal thing, the best practice is that board member to self-report, if you will. Look, I just can't, my mind's made up on this, or I'm biased on this. It's the same thing, again, the litmus test is, what would you want if you were the applicant? You would want somebody to say, hey, I got my mind made up, I'm sorry, you know.
To be fair.
Yeah.
So the our next meeting is going to be March sorry, Wednesday, March the 27th at 6 p.m. Yeah, I had Thursday, but Brian reminded me earlier today that Friday was Good Friday on the 29th. So we slid it back to Wednesday, the 27th. I had not advertised it yet, and I'm hoping that we'll get to a point that we can adopt a Board of Adjustment schedule to have some consistency, and then we don't have to advertise it as a special meeting each time.
We have something on the agenda for 27th already.
We do?
We do?
No,
We have something that we're going to be doing training, or we're going to have.
we have a case coming up.
We have,
Yeah, there's an appeal.
okay.
Brian, question about the hearsay evidence that was presented. It was presented obviously after the motion was made and seconded, but in general, how should the board, because I don't want to necessarily neglect the effort that somebody took to write, a letter either in support of or against, and I recognize that we cannot cross-examine the written document. But how should the board weigh hearsay?
That evidence, and they didn't bring it forth at that time.
But
I said,
if they had presented it in an orderly fashion or as part of their evidence, what obligation does the board have to accept hearsay evidence and or consider it? How much weight, or how would you recommend us proceed with a hearsay in the future?
Well, that depends on several things. One is the nature of the hearsay. If it's an email, odds are they're authentic. If it's a sealed survey, odds are that's authentic. A letter, let's face it, odds are that's probably authentic, but it's much more susceptible to being not authentic. That's one factor, the nature of it. The second factor is who's there. If there would have been 10 people in here tonight that were opposed to this, I would have been much heavier handed in my admonition that it's hearsay.
Right.
I generally, like I said, we follow the rules of evidence in these things, but not as we would in court. My practice is, unless it's just rank hearsay that looks suspect, I generally recommend we allow it in. If someone has an objection, I let them state their objection as much as they want to. I let them examine the documents, state whatever they want to state, and then I'll follow up with the admonition as I kind of did tonight. That is hearsay. That person is not under oath. That person is not here subject to cross-examination. So if it's an uncontested matter, I think it's easier on the board to look at it. If it's a hotly contested matter, that's when you have to say, well, this was properly noticed. These people weren't here. All these people are here that contest this. I don't know how much weight I'm gonna give this.
Thank you.
But
that makes sense.
In general, other than allowing any people in opposition to object and make their case, I rarely have seen anyone not let your garden variety, if you will, hearsay in letters, emails, surveys, things of that nature.
Thank you.
Certainly.
Okay.
Good question, though.
Can we have a,
I'll make a motion to adjourn.
I second it.
All in favor?
Aye.
Paul wouldn't get that one in quick, did you?
You guys have a great evening. Thank you.
You too. Thank you,
Thank you.
Brian. We'll see you later.